All right, everyone, welcome back to Uncontested. I am your guest host, Rob Johnson, and the man behind the show, Sean Lohman, is with me as always. What's happening, Sean?
Not much. How are you doing, Rob?
I'm doing well, sir.
I know it's getting cold in Kentucky, so it must be pretty cold where you are.
It is. Actually, as a matter of fact, I met with a couple of clients the other day, and they're in Arizona, and they had said that, jacket weather is 60, 65, and I'm like, I don't have a full coat until it's 10 degrees. So
I'm sure.
It's just, I guess it just depends on where you live.
Well, winter is hitting Kentucky, that's for sure.
Well, good deal. I love the winter time, so it's not a problem for me. So
that's good.
So Sean, one of the things I really enjoy about working with you on this podcast is there are a lot of serious topics that people hope to never face that they still need to be prepared for. And as you and I were discussing, show topics, one of the proposals you had was to discuss what happens when someone becomes incapacitated or disabled. What steps can they put in place? And like anything, when you're preparing for end of life things or measures, what happens, who gets the children if something happens to my wife and I. Anytime you're preparing for things like that, it's not a fun topic, but it is a super necessary topic. And today, talking about what happens with incapacitation or being disabled is no different. So I'm going to kick it over to you, Sean. So kind of.
And you're right, Rob. And I'll tell you what, it really became clear how important this topic is during COVID. And we'll talk about that later. But I'll tell you, I talk to my clients about this subject every time I meet with them about whether we're doing a will or whether we're doing a trust. No matter what we're doing, we talk about this topic. I talk about it with everybody, and COVID really brings this to light. Because during COVID, you'll remember a lot of people had to make a decision. Does somebody go on a respirator or do they not go on a respirator? And that's when all of a sudden, whether you had made this election in the past, one way or the other, made a huge impact. And really was a life or death decision at that point. And we'll get into that. But I told somebody yesterday that was in my office meeting with me, I said, this went from like number 5 on the list of things to discuss to number 2 or 3. And so it really is a very important topic.
Yeah, and I think you bring up a great point with COVID. It definitely speaks to the immediacy that people need to act in order to get this taken care of, because there were so many stories that were publicized by the news of just people that didn't have the decisions that they wanted. They knew that person would want to have made. They didn't have it in writing. They didn't have it executed. So that's right. I guess from your perspective, Sean, give us a rundown, lay the foundation for the measures people should take.
Yeah. So the question is, what would happen to you? What would happen to you? What would happen to your family if you became incapacitated or disabled? Who would make decisions for you about your health care? Who would make decisions about whether you're going into a long-term care facility or which one you go into? Who would choose your treating physician even? And these are important questions, but even more important are those end-of-life decisions. Who would make decisions about whether you go on life support or if you stay on life support once you go on it? Whether you get artificial nutrition or hydration, or whether that is removed and you're allowed to die peacefully. So these are very real issues that affect us as we age or if we're injured, and cannot make healthcare decisions for ourselves. We think about this subject, Rob, as a subject for when we get old, but we could be involved in an accident tomorrow. Somebody could hit us as we're crossing the street. We could have a stroke and be incapacitated. There are a lot of different things that can happen to us when all of a sudden this becomes a very real issue. And so I try to bring up an example of a real situation that many of us remember. Now, if you're too young, you won't remember this, but we're going to talk about it and you'll understand where we're coming from. But I want to talk about the case of Terri Schiavo. And Terri's is maybe the most recognizable case of someone who lost the ability to make decisions about her own health care and her own treatment and had nothing in place to designate someone or to make these decisions for her. So you may remember Terri Schiavo. She lived down in St. Petersburg, Florida. And in February of 1990, she collapsed from cardiac arrest, which left her in a persistent vegetative state. And despite a bad prognosis, Terri received a lot of care. She received neurological treatments. She received traditional and experimental treatments until 3 years later in 1998, her husband Michael, who had petitioned the court and was appointed her guardian, he went back to court in 98 in Florida to remove her feeding tube. And that's according to state law, since Terri had not designated Michael as the person to make decisions on her behalf. He had to go to court to get permission to remove the feeding tube. So he was opposed by Terri's parents. And Terri's parents said two things. First of all, they said she's a devout Catholic. She would never want her feeding tube removed. And secondly, she's conscious. So, the doctor said, no, she's in a persistent vegetative state. She does not have consciousness. Her parents said she does have consciousness, and this would be a moral issue for her. She would not want it removed. And so they fought. The court ended up ruling in favor of Michael, and just this battle took a couple of years. And the feeding tube was removed on April 24th of 2001. But a few days later, it was reinserted by the ruling of an appeals court. So her parents won in the appeals court, and the feeding tube was put back into place. And then over the next 4 years, I don't know if you remember this, but various interest groups, members of the Florida legislature, the United States Congress, the President of the United States, President Bush, they all became involved in this case. And so there were 14 appeals, numerous motions, petitions, hearings in the Florida courts, 5 suits in federal district court. The Florida legislature got involved, and some legislation that they passed was struck down by the Supreme Court of Florida. A subpoena by a United States congressional committee to qualify Terri for witness protection was issued. So a congressional committee tried to get Terri into witness protection to hide her from her husband. Federal legislation was passed, and 4 denials by the United States Supreme Court for the case to be heard before that court. Imagine how much money was spent on this, how much time, how much fighting was spent on this. And ultimately, the judicial process prevailed, and the original court's decision to disconnect Terri from artificial food and hydration was upheld. So the tube was eventually removed on March 18th of 2005 for the second time, but Terri died 13 days later. And one thing's for sure, one thing we can all agree about is that all of Terri's family, her husband, her parents, they struggled to do what they believed was the right thing for Terri. But unfortunately, even though the option was available to her, Terri had never prepared or signed one single legal document that mattered, and that was a living will. And a living will which would grant the power to someone to act in her place if she was unable to make or express decisions and preferences regarding her own health care, on her own. So had she executed that one simple document, a 3-page document, all of that litigation, all of the congressional involvement, the president's involvement, all of that would have been avoided. And so when I talk about this with my clients, and I'll bring up the Terri Schiavo case because most people remember that, I recommend 2 documents that people absolutely should have in place. And one, yes, is the living will, but one is a healthcare power of attorney. So 2 different documents. And I like to describe these 2 documents to my clients like this. The healthcare power of attorney goes into effect when you lose capacity, the ability to make your own healthcare decisions. So it could be, like I said, that you were in an accident and you need to have decisions made about surgery. or going to a rehabilitation facility. It could be that you need a doctor, somebody to decide who's your treating doctor going to be, or to choose a long-term care facility for you. Or a decision for hospice care needs to be made. Who's going to make that decision? So the healthcare power of attorney goes from the time incapacity is made up until end of life decisions need to be made. Then you have the living will, and the living will deals exclusively with end of life decisions. If you're incapacitated and cannot make decisions for yourself, do you want to be placed on artificial life support, or do you want to mandate that artificial life support be withheld? Do you want artificial food and hydration, or do you want to mandate that artificial nutrition and hydration be withheld? Or do you name a healthcare surrogate, a person, a trusted family member, or a friend who is present, who's talking to the doctors, who understands your condition, who can actually see you, and they understand what you would want as far as these artificial life supporting treatments go? Do you depend upon that healthcare surrogate to make decisions that are in your best interest, and that would serve you best? And so with a living will, if you have one in place already, or not, you can you can either mandate the withholding or withdrawing of artificial food and hydration. You can mandate the withholding or withdrawing of artificial life support, or you name a healthcare surrogate and you state, I'm not mandating it one way or the other as far as food and hydration go. I'm not mandating one way or the other as far as artificial life support goes, but I leave it up to my healthcare surrogate to do what's in my best interest. So a lot of people have one in place and they think, okay, this is already in place. But I cannot encourage people enough to review their living will with an attorney to make sure that it really reflects what they desire and that they've thought through the decisions that they've made and whether or not those decisions result in the intended consequence. So an example of that is, when I first started practicing now over 28 years ago, most of my estate planning clients were my parents' age. So, I was mid to late 20s and I'm doing estate plans, and, most of the people were, quite frankly, in their 40s or 50s, my parents' age. Some were my grandparents' age. And 99% of them said, I do not want to be on life support, period. Now, why would they say that? Well, they remembered the days when life support was, just a big machine, and it looked incredibly uncomfortable for people to be forced to breathe, and there were a lot of reasons that they had that they did not want to be on one of those machines. So they didn't want to leave it up to their healthcare surrogate to make these decisions on their behalf. They just flat out said, I don't want to be on life support. And they would check that button, and I would respect their opinions. But then what happened during COVID and during the COVID pandemic? And doctors were saying when somebody would go to the hospital, if we could put them on life support for 3 or 4 days, if we could help them with their breathing, then we think we can get them past COVID. So the doctor would look at the family and they'd say, does your loved one have a living will? And the family would produce the living will. And if the will said what most of my clients' living will said, and I said will, I meant living will, but if the living will said what most of my clients said, which was I mandate the withdrawal or withholding of artificial life support, then guess what? Those people died. They were not allowed to put them onto life support. So, thousands of people, because the doctor could not administer this artificial breathing support, given the decision that they made mandating no life support be used, died. So I encourage people to absolutely get a living will in place. number one, that's an important thing. But
Yeah.
if you have a living will in place, have it reviewed every few years to make sure that it accurately reflects your wishes and ultimately that the outcome that you want is going to be the one you want. Um, I had a lot of clients come back in and review these with me, especially in the last year, as you can imagine, since COVID. They want to change, their mandate of no artificial life support, the mandate of no artificial food and hydration, and instead they want their healthcare surrogate who they've designated to make those decisions on their behalf. And it just makes sense, right? Because those are the people that are in the hospital room with the doctor while their loved one is incapacitated, and they have more information than you had when you signed that living will. And so it makes sense to leave it up to that person to make that decision. Now, when I have these conversations with clients, they will inevitably say, "But I don't want to be on life support for the rest of my life." And that's fair. And you can restrict the amount of time that you're on life support. But I think more realistically and maybe better, have a conversation with your loved one. Have a conversation with your friend. Have a conversation with the person that you've appointed as your healthcare surrogate so that they understand, you know what? If I have terrible pneumonia and the doctor says, if we put her on life support, um, she'll come out of this likely. We need to help her breathe while the antibiotics take effect. It's too hard on her body right now. Okay, you know, um, don't just let me suffocate to death. Um, Allow me to go on the life support so that the antibiotic has a chance to take effect. But I don't want to be on there for more than 2 weeks, or I don't want to be on. If the doctor says, "Look, this isn't working," um, then take me off of the life support. So it's from the way I see it, it's not a black or white decision for most people anymore. This is a decision that there is a lot of gray, and and I think that is that's something that's worth discussing, with your attorney about whether or not these decisions need to be revisited and maybe changed.
Now, Sean, in that particular case, do you think the reason it was prolonged like that is because Terri's husband waited so long to make a decision? Because it was like 8 years, right? And
No,
isn't that what sparked the controversy?
it had been 3 years before he went to court and asked for permission to remove the tube. But during those 3 years, at first they were hoping that she would come out of it.
Right.
Um, and then they gave her the diagnosis that she was in a persistent vegetative state.
Okay.
So that took several months. But then over those period of years, he continued to do neurological therapy. And like I said, experimental therapies, experimental
Yeah.
treatments. He tried everything to try to get her out of that vegetative state. But the doctors finally said, she's never going to, this is going to be her life.
Sure.
Um, you know, Laying in a bed, sitting in a bed. She does not have any cognition. She is not conscious, even though her eyes are open. She is not conscious, and so um, it was a choice that he was making as her husband as to whether or not she would want to live the rest of her life like this. And but the parents had just as much standing before the court as her husband did. Anybody could have petitioned the court to be named her guardian. And
I see.
so, when they came in and objected, they were taken as seriously and as, the court was just as concerned about their opinions as they were her husband's. And that's what resulted in this dragging out. So
Yeah.
I think that the
Okay.
fact that he gave her 3 years worth of treatment and he tried everything possible,
Mm.
and to prove that everything had failed, I think that helped his case. But I see what you're saying.
Yeah.
I mean, but I think that he was able to look himself in the mirror at the end of the day and say, "I tried everything,"
Oh, for
and
sure. Yeah.
and she would not want to be sitting like this or laying in this bed like this for 20, 30 years. The only way she's staying alive is because she's getting artificial nutrition and hydration. So
Yeah, it's not a typical case. This is kind of the first time something like this is echoed through the media realm and through political circles, and
that's
it's
right.
pretty groundbreaking. So,
That's right. And I think a lot of questions come up. Well, how old do I need to be? Right? How old should I be before I think about this? How old does someone need to be? Isn't this just for old people? Well, Terri Schiavo was in her 30s. And so, she was young. And if you're over the age of 18, your parents can't make decisions for you anymore. We can't make decisions for our kids. My kids are 27, 26, 25, and 21 right now. And even though I'm their dad, I do not have any legal authority to make decisions for them regarding anything of this nature. So I would have to go to court. I would have to petition the court to be named guardian of their person. I would have to petition the court to be named conservator of their funds in order for me to make decisions on their behalf. And at the same time, their mom could petition the court for the same thing. And at the same time, their grandfather, who's a doctor, could say, well, actually, I'm in a better position than any of you all to make decisions on my grandson's behalf because I'm a physician. And he could petition the court to be named his guardian. And his siblings could say, well, you know what? These are all older people. We know what he would have wanted. We were his siblings. We actually talked about this. We know what so they could petition the court. And suddenly you have everyone you love in court and in conflict and fighting because you never exercised this. And if you're older, if you're my age, you could have a spouse and a parent fighting over you, like Terri Schiavo did. You could have children fighting with their step parent. If this is a second marriage, they could be in court fighting against each other over who's going to make decisions. Keep in mind, everybody who thinks it's automatically the spouse that makes these decisions, the spouse is not necessarily deemed by the court to have their incapacitated spouse's interest at heart. Who's the beneficiary of the life insurance? Probably the spouse. Who stands to inherit everything from the disabled or incapacitated spouse? Probably the non-incapacitated spouse. So just because you're married does not mean that your spouse is deemed to have your best interest at heart. So if you want your spouse, which is 99.9% of the time, if you want your spouse to make those decisions, you need to name them. And you need to keep them out of court and fighting with your kids or your parents or somebody else over who becomes your guardian. It's a very short document, but it is an incredibly powerful document.
no, I love that,
You know,
Sean.
it is very powerful. Now, last, and this is a third document. I said I was going to tell you about two, but I'll tell you about a third one, and that is a HIPAA release. And HIPAA, we've all come to know HIPAA, the Health Information Portability and Accountability Act is what it stands for. HIPAA for short. It's a federal statute that says you have to have a signed release waiving your healthcare privacy rights for someone to get information from your medical provider, or your doctor, a nurse, any information about you. They have to have a release before they provide somebody with that information. That includes an 18-year-old whose parents go with them to the pediatrician. I've had that happen. It's like your kids are 16, 17, you can go back with them. You can talk to the doctor. The doctor will tell you anything you want. On their 18th birthday, suddenly they say, oh, no, you can't come back. So, well, we can't talk to you unless your child tells us it's okay. By the way, they'll still take your check for the copay for the insurance.
Sure, they
but
will.
They don't want to give you any. But they don't want to give you any information because of HIPAA, and it's fair. Okay, that's the statute. That's the law. They are just doing what the law requires. But let me tell you what happened to me when my daughter was at the University of Texas, and she was a swimmer there, and she got up one morning and she fell, and she fractured her jaw. She dislocated her jaw, knocked out a tooth, lacerated her lip, broke her nose, and lost consciousness. And so I find out through her friend that she's been taken to the hospital. Her mom and I are scrambling to get from Louisville, Kentucky to Austin, Texas, calling the hospital. They can't tell us anything. The hospital won't give us any information. Why? Because I didn't have my own kids sign a one-page document, a HIPAA release, one-page document. If she had signed that for her mom and myself, we would have been able to text it, to email it, to fax it, to do whatever we needed to do to get it to that nurse's station so that doctor or the nurse who was caring for her could tell us what was going on with our little girl. So, we're scrambling to get there, and she's on morphine. She's in incredible pain. She can't release anything. So it was hours and hours before we could find out what was going on with her. So, that's incredibly important to have a HIPAA release signed for those reasons, but also if you are named as somebody's healthcare surrogate. So let's say that you're named as a healthcare surrogate in that healthcare power of attorney, and somebody was just involved in an auto accident. They're just in their 50s, and you're their adult child or whatever, but you don't know if they're capable of making their own decisions. Well, how do you find that out unless you have a HIPAA release?
Right.
So you may be the person named. You may be named to take care of their healthcare decisions for them if they're incapacitated. But how do you know if they're incapacitated if you can't talk to their doctors and their doctors can't give you that information?
Right.
So this is, I don't know a lot of attorneys who automatically do HIPAA releases for everyone that they do plans for, but we do. It is an absolute necessity, and I would never do an estate plan that did not have a HIPAA release, but just as importantly, a healthcare power of attorney, and then, the most important document, which is the living will. Those are your three healthcare documents that you really need to have an effect to keep your family at the end of the day out of court and out of conflict with each other.
I love that, Sean. That's all great information.
Yeah.
And as always, I appreciate you walking myself and the listeners through that.
Absolutely. And of course, if anybody has any questions, if anybody wants to learn more about this or about estate planning in general, they can go to our website, lohmanestateplanning.com, and click on the webinar link and watch our webinar. It gives more information about, some general estate planning, or go to that website and click to make an appointment right at the top of the page. You can make an appointment with us. You can schedule a 15-minute phone call to get more information, or you can jump right in and schedule a planning session, and we can discuss, what happens to you, like we discussed today, what happens to you personally if something were to happen to you, but also what happens to your assets. What happens to all those things that you've worked so hard for over the years, and how can you control those assets and protect your family, not just if you're incapacitated and you need help with making your medical decisions, but how do they continue paying your mortgage, paying your insurance, paying your car payment, those sorts of things that are very important, which deals with financial stuff, and we didn't touch on that today, but it's just as important, and we can handle all of that for you and discuss that with you and give you your options in a free phone call or a free planning session. So don't hesitate to reach out to us. Yeah.
No, that's excellent. And for the listeners, all of the information that Sean had mentioned is going to be in the show notes. So if you want to watch the webinar, schedule a planning session, or just learn more about what Sean and his practice does, you can go ahead and check all of that out in the show notes. Well, Sean, thanks as always.
Yeah, absolutely. Thank you, Rob, and thank you to everybody listening.
All right, guys, that's going to wrap up another episode of Uncontested. We'll catch you on the next one. Take care.